how do you separate the value of a business versus the person who's running it?
There is a difference between.
Welcome, everyone. This is the Illinois Family Law Insider. My name is Katie VanDeusen, and I am the managing partner of Sterling Lawyers. Today, I have with me Senior Associate Cynthia Toscano. Welcome, Cynthia.
Thank you for having me, Katie.
Today on the podcast, we're going to be talking about valuing businesses and divorce, and what does that really look like, what that process looks like, and how do we determine what a business is really worth. Starting off with business valuations, Cynthia, in your experience, what are the main methods of valuing a business, or how do you even go about taking steps to value a business in a divorce case?
So it really depends on the kind of business that it is that'll inform what is the best approach to value it, whether it's a franchise like a restaurant or whether it's like a homegrown plumbing business or whatever it may be. But there are really three main approaches to value business. It's the income approach, which is essentially a multiplier of how much income the business is bringing in on an annual basis. The asset approach, which is really taking into account all the assets a business owns, including, tools, buildings, land, all of that, to see what it could be sold for if we had to dispose of the business. And then the last approach, which is a little bit more of the most complex approach, is what we call the market approach, which is essentially like, if we decided to list this business tomorrow, what could we get for it on the open market? And that really is more appropriate for things like franchises or things like businesses like that could be sold easily. It's harder for like homegrown businesses that don't really have any assets. It's really just the value comes from the employees or the service that's being done. But really, depending on the business that we are discussing in any particular case, is sort of going to inform which approach we think is best for providing a valuation for it.
That makes total sense. And I always feel like in practice, it's almost like a step that the attorney has to take in determining whether or not this business is a stream of income or a piece of property, or maybe even both, right? And that kind of dictates exactly what you said, how you value it and how you kind of interact with it during the divorce case. And typically, Cynthia, do you feel like whenever you have a business, you're retaining an expert to value it, or do you sometimes make that decision as the attorney, having that conversation with the client as to whether or not the cost benefit analysis is there?
To be honest with you, it's probably about a 50-50 in terms of how many times we're retaining experts in order to value a business, because a lot of times it is worth it to retain the expert. Experts are not, what we would call affordable. They do cost several thousands of dollars. A business valuation can cost upwards of $5,000. I've seen up to $15,000 to $20,000 depending on the expert and how large the business is and how complex. So it is definitely not something that we would call affordable. And a lot of times it is worth it because it is what we would call a large complex business that could be worth hundreds of thousands, if not millions of dollars. And in that scenario, it's absolutely worth it to figure out what portion your client could be entitled to. However, there are other scenarios where, for example, I had a case one time where my client was a specialized repair person of medical devices, and he was self-employed through his business, but there were really no sort of assets. There was no employees. It was just a corporation that he used as a method to be self-employed. In that scenario, we could value the business. We could hire sort of a CPA to look at the income and see what his book of business could sell for if he really wanted to. But even if he wanted to sell his book of business, it's a service that is very specialized. It would be very difficult to sell that. And for that reason, the value really wasn't there. And when we were doing that cost benefit analysis of, is it worth it to pay upwards of $5,000 for something that we're fairly certain wouldn't really sell on the open market, or isn't really something that could be sort of passed on or gain any sort of value from if it were to be sold? In scenarios like that, it's really not worth it. And instead, we start looking at offsets. So for example, we know the business has some value. We don't know what that value is, but we know it's some. So in order to offset whatever, small value we're attributing to that business, we'll maybe do an extra percentage off another asset like house proceeds or retirement account or something of that nature that both parties can sort of feel comfortable with.
And then definitely looking into like the tax effect when you're offsetting like that with retirement versus the value of a business and kind of what that looks like. You kind of alluded to this before, but can you tell us, like, how do you separate the value of a business versus the person who's running it? Can you talk to us a little bit about how that would work in a divorce case?
Absolutely. There is a difference between income and assets, and sort of how we are deciding to value the business is going to inform how we decide to label that income, because a lot of times, for example, an owner of a business will receive some sort of salary or some sort of bonus or some sort of percentage of profits, and that is income. And that is separate from what that owner would get if he decided to, list his business on the open market tomorrow and see what he would get. So we do our best to separate what is being reported on the taxes, on the pay stubs, on the profit and loss statements as income to a specific person that then is used for purposes of, maintenance and child support calculations, as opposed to, assets or a value that is intrinsic to the business, that isn't just something liquid that can be pulled out, that would have to be sold for value. And then that is listed as an asset that then must be divided between the parties or allocated between the parties as part of the divorce proceeding.
Yeah, I recall I had an attorney who owned their own practice in a case, and that personal goodwill or the fact that the business was so closely tied to that particular professional doing the actual like legal services, that that business really didn't transfer, couldn't just be sold out on the open market, so I definitely think that is a complicating factor and kind of another level of analysis that the attorney has to do in those types of cases. And then, Cynthia, in your experience, do you typically see parties hiring like a neutral business valuator where they both are agreeing to retain a certain expert and, using that jointly, or utilizing that expert jointly? Or do you find that a lot of cases, each party is kind of retaining their own individual expert, and you kind of have this dueling expert type of interaction in a case?
I would say that most of the time parties do end up jointly deciding on a neutral third party expert. And again, that goes back to the whole affordability factor, because if you are paying several thousands of dollars to get a valuation, it's better for both of you to decide on someone that you agree with that's going to provide, accurate, precise, and neutral report, and only have to expense that once, as opposed to arguing over who the expert should be and then paying double for essentially the same result. So a lot of times I would say parties do end up agreeing in order to preserve the marital estate and to, save on those funds. But there are some cases where, again, if the business is very, very valuable and the parties really are at odds as to one, how it should be valued, and two, what the value is, the cost benefit analysis ends up being different, because if you think you're going to get hundreds of thousands, if not millions of dollars from a business, you're okay expending an extra 10, 15, whatever it may be to get your own report if you think it's going to serve your argument and your interest better.
Definitely. And then have you seen in your experience any common red flags or kind of manipulation tactics when it comes to involvement of a business in a case?
Yes, anytime there's any sort of dissolution proceeding, you always got to look out for red flags, because parties always think that there's things that they can get away with that a lot of times they can't. So I would say typical red flags that we always look out for when we're doing sort of valuations of businesses, and if there's all of a sudden a decrease in income, all of a sudden the business isn't doing so great, all of a sudden our customers aren't coming back, like that's definitely a red flag, especially if there's been consistent income or profits, or even if it's been increasing and all of a sudden there's a dip that can't really be explained by external factors, like there hasn't been a change in the law or in the market or anything like that that could affect the business. That's a red flag. There are times where parties think that they can hire what we call ghost employees, where they're saying, I have all the expenses for all these employees, but no one can find the employees or where that money's going. Another typical red flag we see is what we call ghost depreciation, where they're claiming that their business assets are depreciating at an X amount rate. And that's because, legally their CPA and the IRS accepts a certain amount of depreciation every year. So they're, in accordance with tax laws, but that doesn't mean that that's a depreciation that's actually happened. And that doesn't mean that it's a depreciation that a business valuator should take into account. So I would say those really are the three main sort of red flags that we look out for when we're valuing a business. And all of a sudden then there's these changes that no one can really account for or explain.
And then what do you do from a legal standpoint to kind of combat those red flags? Like if you have a client who is expressing that that may be on their mind or a concern, or you even maybe review the business records and start kind of getting those red flags or seeing those transfers or red flags come up, what is your next step as an attorney?
the first step is to reach out to the business valuator and make them aware of this issue. You're going to point to the exact issue and you're going to say, my client thinks they're ghost employees. If you please refer to this document, he's claiming that he's paying X amount in employees, but if you look at this other document, there's only 3 employees listed. Or if you look at the tax returns, he's claiming this depreciation, but if you look at the list of assets, so you really want to point the business valuator to exactly where you see the red flags so that they know exactly what they need to look out for, and then they can dig into it specifically to make sure that that issue is addressed as part of the business valuation, so that when it does come back and your client is like, what about this that I told you? You can say the business valuator specifically looked into X, Y, and Z to address this issue, and this is what they found.
Absolutely. I totally agree with you 100%. And then, given your experience, Cynthia, is there any circumstance or experience that comes to mind where you had on paper, maybe this business was failing, but when the business valuator or maybe a forensic expert looked into it further, that review told a completely different story?
Well, it's not necessarily that the business was failing, but I had a specific case where the opposing party was a general contractor and he had his own, what we call construction business. It was a corporation and he didn't really have many employees. They were what we call subcontractors, meaning they weren't direct employees of the business. They were 1099 employees that he would contract on a per job basis. And they were really trying to make the argument, much like that attorney case you mentioned, where the value really came from the goodwill that this general contractor had with his customers. That if he wasn't around, there really would be no value to the business. And while that does apply to very specialized professions like attorneys, like that other client that I mentioned that worked on medical devices, when it comes to jobs like general contractors, where most of their sort of goodwill or business doesn't come from specialized knowledge, but more sort of like management and delegating and things like that, that book of business can be transferred to any general contractor. And there's a dime of dozen in the Chicagoland area with all the houses and large population. So in that situation, they were really arguing that the value of the business was zero, that the corporation was zero, because if he decided to sell it tomorrow, all his customers would leave and it wouldn't be worth anything. And it really was a sort of uphill battle to try and prove that the business had a value because they weren't being cooperative with and I wouldn't say the attorney, but the party wasn't being cooperative with the profit and loss statements, the tax returns, things of that nature. And they wouldn't even agree to a business valuator. So my client decided to, out of her own pocket, do it herself because she knew he wouldn't be cooperative. And it ended up working out for her because once we got that business valuation, we were able to prove the value that we thought the business had. He wasn't willing to put out of pocket for his own business expert, and the judge just ended up accepting our valuation because the judge had nothing else to compare it to. So there are situations like that where, despite the other party's insistence or stubbornness, you take all the right steps and do everything you're supposed to do. You end up, persevering on the issue you're fighting over.
Absolutely. And strategically, what a good move for you to make in terms of that by securing your own expert. It may have been a pain point early on with the client and the cost, but wow, was it worth it in that instance? Clearly. And to kind of wrap up with one final question, just to kind of get your feedback, Cynthia, what's one thing, if a business owner is facing a divorce, what's one thing that they should start doing or stop doing?
Absolutely. What's one thing that they should start doing is making sure they start gathering all their records. Make sure that they have a safe place where they keep their tax return, their profit and loss statements. Make sure they're in communication with their CPA so that they know that the records are as accurate as they could possibly be, and there's nothing that's being mistakenly reported or not being, documented appropriately. Make sure that they have all the documentation they need so that when it does come time to do the business valuation, the expert doesn't have to struggle so much, and it'll be more cost effective for all the documents to be ready to go and the expert to start doing the business valuation. And then one thing I would say that they should avoid doing is, and this just applies in general, there really shouldn't be any big or major changes before a dissolution, and that applies to businesses as well. So if you're thinking of making like a pivot in terms of strategy or marketing or a giant investment or a giant, acquisition or growth or anything like that, I always tell people any major changes like that should really be put off until after a dissolution, because one, it's going to complicate the case because there's going to be different interpretations of what that change means in terms of the value. Two, it's going to make the business valuation more expensive because now the expert has to take into account all these extenuating factors that didn't really exist before. And three, it just causes additional litigation that could have been saved if maybe that specific change had been postponed until after the dissolution proceedings.
What words of wisdom. Thank you so much, Cynthia, for coming today on the podcast and for talking through these topics and just how poised you are and the knowledge that you have and the experience you have. It is awesome. So I
Thank
hope
you
that
so much.
everyone learned something from this. And thanks for coming to talk about valuing businesses and kind of what we should do in divorce cases and how to determine their value. Thanks so much, Cynthia.
Thank you for having me.
Valuing a business is just one piece of the financial puzzle. But here's what most people in Illinois don't realize. Even without a business, you can still end up spending way more than necessary during a divorce. Why? Because the hidden costs start long before you get to court. So watch this video to uncover the most common financial traps and how to avoid overpaying for your divorce in Illinois.